Good morning. This is your Kelso Report for Thursday, September 22nd, and I'm your host, Clark Kelso. Well, as we have noted several times in recent weeks, the legal fallout from the collapse of the housing market and the subsequent financial collapse have started hitting the appellate courts. Quite a few of the early cases have focused on the foreclosure process, but today we look at a Ninth Circuit decision that involves the behavior that started the ball rolling. Selling homes using subprime mortgage standards to buyers who probably couldn't afford the homes they were buying. The plaintiffs in yesterday's decision in Maya versus Centex Corporation are individual homeowners who purchased homes in new developments constructed by one of 8 large national home builders between 2004 and 2006. Each of the plaintiffs made a down payment of 20% or more of the home's purchase price. These were not subprime buyers. The complaint seeks damages and the option to rescind their home purchases due to defendants' fraud, negligent misrepresentation, breach of implied covenant of good faith and fair dealing, and violations of California's Business and Professions Code. The basic factual allegations are that the defendants represented they were building stable family neighborhoods occupied by owners of homes, and that implicit in this marketing strategy was that defendants were making a good faith effort to sell homes to buyers who they expected could afford to buy the houses and would be stable neighbors. Notwithstanding those representations, defendants actually sold to buyers who couldn't afford the homes they were buying and who posed an abnormally high risk of foreclosure. And the defendants facilitated those sales by financing many of the sales themselves, which created an artificial buying frenzy. Unfortunately, it was a buying frenzy based on fraud, which, when the defaults and foreclosures started coming, destroyed the market value in the plaintiffs' homes. The plaintiffs allege injuries that occurred both at the time of the sale and injuries after the sale. As of the time of the sale, plaintiffs allege they paid more for their homes than they were actually worth, and they would not have purchased their homes had defendants made the proper disclosures. The post-sale injuries were, of course, that their homes had decreased in economic value and desirability as places to live. The defendants filed a motion to dismiss, arguing that plaintiffs first lacked constitutional standing, second, failed to allege their fraud-based claims with particularity, and third, failed to state a claim as to each cause of action under Rule 12b-6. The district court dismissed solely on the grounds that plaintiffs lacked Article III standing. The Ninth Circuit reversed. To satisfy the constitutional requirement of Article III standing, a plaintiff must show, number one, it has suffered an injury in fact that is concrete and particularized, and actual or imminent as opposed to conjectural or hypothetical. Second, the injury must be fairly traceable to the challenged action of the defendant. And third, it must be likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision. The trial court had concluded that the injuries alleged by plaintiffs were conjectural and speculative, and that the injuries were not fairly traceable to the defendant's conduct. The Ninth Circuit disagreed with both of these conclusions. On the question of whether plaintiffs had suffered injury in fact, the trial court concluded that because none of the plaintiffs had actually sold their homes yet, and because the value of their homes fluctuated based on so many other market factors, the complaint failed to identify a concrete and particularized injury that was actual or imminent as opposed to speculative. The Ninth Circuit found that the district court's explanation missed the point. The plaintiffs had alleged their homes were overpriced when purchased because of the misrepresentations, and lost substantial value later on when the inevitable foreclosures started. For Article III purposes, according to the Ninth Circuit, these allegations are sufficiently concrete and particularized. The closer question, in my view, was on the issue of whether the alleged injuries were fairly traceable to the defendant's conduct. The district court reasoned that the factors affecting home values included quite a few market conditions over which the defendants had no control whatsoever, and that it was too great a stretch to try to connect defendants' sales practices which essentially were the same sales practices engaged in by all developers and home sellers everywhere, to the housing bubble, and then the housing and financial system collapse, which resulted in home prices first being too high and then falling back to earth. The Ninth Circuit disagreed with the trial court's analysis, reasoning as follows, quote, "Construing the facts in the light most favorable to plaintiffs and drawing all inferences in their favor, plaintiffs have sufficiently alleged that defendants, not third parties, inflated the bubble in their particular neighborhoods, causing plaintiffs to overpay. Plaintiffs claim that defendants financed a substantial majority of buyers in plaintiffs' neighborhoods and were thus able to dictate the terms of a large number of loans and plausibly create demand that would not otherwise have existed. Further, the neighborhoods were new developments, so there was no independent economic baseline against which to assess the neighborhood's value. Under these circumstances, plaintiffs can plausibly claim that the artificial demand created by defendants' marketing and financing practices had an identifiable effect on the price they paid for their homes." Close quote. Now, I read this in essence as saying these development areas were little islands unto themselves, where the developers could magically control supply and demand irrespective of developments outside these islands, and the developers could thereby mislead buyers about the true value of what they were buying. Now, I do think it raises a very interesting question of who can be held civilly liable, if anyone, when an irrational bubble takes over an entire market, thereby inflating prices temporarily everywhere, but leading ultimately to a crash in value when the bubble pops. The housing bubble was not the result of a single entity perpetrating a fraud. It was an entire market that simply spun out of control, both sellers and buyers. In a sense, the problem for the courts is whether any one participant in that market can be held responsible for its unreasonable behavior when the entire market was behaving unreasonably, at least in retrospect. When everyone is acting unreasonably, how do we determine who is reasonable and who isn't? In the particular case before the Ninth Circuit, the parties will go back to the trial court, which will now have to decide whether the plaintiffs had pled fraud with sufficient particularity and whether the complaint states a claim on which relief can be granted. I have a feeling this case will be coming back up on appeal, because my guess is the district court will dismiss on either of both of those grounds. Well, we only have one liner for today, one-liner, in dealing with a discovery problem. In the matter of Roman Catholic Archbishop, the Ninth Circuit held that certain discovery documents which had been disclosed to the bankruptcy court and filed under seal would remain sealed after the conclusion of the bankruptcy proceedings. The documents were internal archdiocese reports of sexual abuse by priests within the archdiocese. The documents named 2 priests who had never been publicly accused of sexual abuse. One of the priests was now 85 years old, had retired in 1989, and had never had a claim of sexual abuse filed against him. The other priest was still active in the archdiocese, though he too had never had a claim of sexual abuse formally filed against him. The Ninth Circuit held that the name of the retired priest should have been redacted, because there was no remaining public interest in knowing his name, but that the name of the active priest should be disclosed, given the public's strong interest in public safety and in knowing who might still sexually abuse children. Well, that's it for today's Kelso Report. Have a great day in the law.